Man, if Duncan versus Bonta goes the way it's looking, we're not just talking about mags anymore. We're talking about the next big wave of gun laws getting wiped off the map. This one case could crack the whole system wide open. What's up, everyone? This is Ted from Line 45, and today we're diving into Duncan versus Bonta, or the Supreme Court case that's got the potential to tear the guts out of magazine bans and take a few other gun control laws down with it. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up, and let's get back to the video. I've watched a lot of gun cases get chewed up in court over the years, but this one's different. Duncan versus Bonta isn't just some technical challenge. It has got real teeth. When the Supreme Court pulled that rare procedural move to fast-track it, that wasn't business as usual. That was a signal. This thing could blow open the doors on how every lower court handles Second Amendment cases from here on out. What Duncan is fighting is California's ban on so-called large-capacity magazines, which are anything over 10 rounds. But this case is less about the number and more about how the government justifies bans like this in the first place. Since the Bruin decision came down in 2022, courts are supposed to ask one simple question: is there a historical tradition back in 1791 for this kind of restriction? Spoiler alert, there ain't. If Duncan wins, it becomes case law that magazines holding more than 10 rounds are covered under the Second Amendment because they're in common use. That completely shuts the door on the old trick of calling these bans reasonable or public safety measures. I've said it for years. When courts quit pretending they're gun experts and start following the actual Constitution, a whole lot of these bans won't survive the daylight. And once this cracks, other laws built on that same shaky logic are in deep trouble. Every time I hear politicians talk about banning assault weapons, I have to roll my eyes. They act like it's some clearly defined category, but it's just a made-up label for rifles that look scary. I've owned AR-15s for decades. They're lightweight, accurate, easy to shoot, and incredibly common. There's nothing exotic about them, no matter how many buzzwords they throw around. And that's exactly why these bans are starting to fall apart. If Duncan versus Bonta shuts down California's magazine ban on the grounds that those mags are in common use, then you better believe the same logic applies to rifles like the AR. According to the National Shooting Sports Foundation, over 24 million modern sporting rifles are in circulation in the U.S. That's more than F-152nd on the road. Courts have already acknowledged in Caetano v. Massachusetts that the Second Amendment covers arms in common use by law-abiding citizens. That sets the table. You've got lawsuits like Rupp versus Bonta and Bianchi versus Frosch just sitting on deck. They're challenging the bans in California and Maryland, and you can bet they're watching Duncan closely. If SCOTUS affirms the standard that common use equals constitutional protection, the legal argument behind assault weapon bans gets gutted. I've always said banning a rifle because of a pistol grip or flash hider is like banning trucks because of their paint job. If Duncan wins, courts will finally have to admit that cosmetic features don't make a rifle less protected. It makes the ban less legal. More than anything, it proves we're finally past the point of pretending feel-good laws actually hold up under real scrutiny. Now, this is where things get real stupid. Some states think they can get around the Second Amendment by not banning guns, but by choking off the ammo. California's one of them. They've got a background check just to buy bullets. You walk in, try to grab a box of 2, 3, or 9 mil, and they treat you like you're buying explosives. And if you're not in their little system, or your name's spelled wrong, you're denied on the spot. No due process, no appeal, just no. That mess is tied up in a case called Road versus Becerra, and it already got smacked down in district court a few years back. Judge Benitez said the whole ammo check law was unconstitutional, plain and simple. But the Ninth Circuit put it on hold. Thing is, that was before Bruin. And now, with Duncan back in the spotlight, it's going to shift how courts look at these ammo laws entirely. There's no historical tradition, and again, none, for regulating how much ammo a person could buy or carry. Hell, back in the 1702nd, folks were expected to keep powder and shot on hand as part of being ready. If the Supreme Court drops the hammer in Duncan and holds the line on historical analogs, then laws that limit ammo sales or purchases don't stand a damn chance. And trust me, once these start falling, states like New York and New Jersey are going to have a hell of a time defending their own ammo schemes. Now, I also want to talk about microstamping mandates and how they're quietly killing the handgun market. If you've ever tried to buy a new handgun in California, you know the state roster is a joke. Most of the pistols on there are models that dropped around the Obama era, and good luck finding anything new that isn't a single shot or museum piece. Why? Because of this ridiculous microstamping requirement. California says every new semi-auto pistol must have tech that imprints a microscopic serial number on each cartridge casing when fired. Sounds futuristic, right? Yeah, except no gun maker can actually do it. Not reliably, not affordably. So, no one sells new handguns in California anymore. It's a slow-motion ban with a fancy name. Now, this is where Duncan comes in. If the court rules that standard capacity mags are protected because they're in common use and there's no historical basis to ban them, that same principle slams the door on microstamping laws. There's number 1 8th century version of, you can have a musket, but only if it stamps your name on the powder residue. These tech mandates are brand new inventions, cooked up by folks who want to make compliance impossible. The case to watch here is Boland versus Bonta. It's already ruled against California's roster laws, saying they violate the Second Amendment post-Bruin. But Duncan winning would give Boland serious reinforcements, which is an ironclad confirmation that the state can't regulate a right into extinction through impossible standards. If you can't buy a commonly owned pistol today because of some fantasy tech no one can build, then it ain't regulation. It's prohibition dressed in lab coat language. And once that's clear, red flag laws are going to start looking mighty shaky, too. I've talked to folks who think red flag laws sound reasonable on paper. Just a temporary measure, they say. Take the gun, sort it out later. But if you've ever seen how these things actually play out, it's a damn mess. No charges filed, no crime committed, sometimes no warning at all. One phone call from a neighbor or ex, and boom, your rights are gone with a knock on the door and a signed court order you never got to fight. Now, I'm not saying the state doesn't have a role in stopping dangerous people, but Bruin set a line in the sand. If it ain't grounded in historical tradition from 1791, it's on shaky legal ground. Show me a founding-era law where the government could disarm someone without a trial, without a criminal charge, just on someone else's word. You won't find it. That's why these red flag laws are starting to feel the pressure. Duncan winning would tighten that noose. Because if the court rules that even magazine bans can't survive without historical roots, then what do you think happens to laws that skip due process entirely? Courts will be forced to ask the same questions they're asking in Duncan. Does this kind of government power have a basis in American history, or is it just a modern workaround? If the answer's no, and it is, then red flag laws aren't going to make it through the next round of serious legal scrutiny. And if they fall, so will all the new tricks states are using to bury concealed carry under red tape. After the Bruin ruling in 2022, California and states like New York had a meltdown. They were forced to dump their old may-issue carry systems, where the sheriff could just say no because he felt like it, and replace them with shall-issue setups. But anyone who's tried to get a carry permit in those states since knows it's still the same game. They just rewrote the rules with a different flavor of roadblocks. Long wait times, vague good moral character clauses, sensitive places lists that cover half the damn map, all designed to discourage you from even applying. Thing is, courts are already seeing through it. Look at Antoniuk versus Hochul in New York, where a judge called out the state for sidestepping Bruin with fake compliance. Same tactics, new packaging. Duncan v. Bonta has nothing to do with carry laws on the surface, but the legal standard it reinforces, the text, history, and tradition test, is the same one these new carry restrictions are failing hard under. If the Supreme Court throws out California's magazine ban because it lacks historical support, that ruling will echo loud and clear in carry permit battles. It sends a message: no more clever tricks. No more bureaucratic games to block law-abiding citizens. I've seen folks jump through every hoop and still get denied for nonsense. If Duncan tightens the leash on judicial interpretation, these states won't be able to hide behind paperwork anymore. And if you think this is just a state issue, wait till we hit the federal level. Things get even spicier there. You talk to most gun owners, and they'll tell you, State laws are bad, but federal laws are where the rot really sits. The National Firearms Act of 1934, the Gun Control Act of 68, the Hughes Amendment in 86. These aren't small regulations. These are the laws that locked suppressors behind months of red tape, taxed short-barreled rifles like they're illegal contraband, and cut off full auto ownership for the average guy. And for years, nobody really touched them. Courts were scared too. Lawyers said it was settled. Gun owners just lived with it. But Duncan might be the crack in that old concrete. Because if the court rules that California's magazine ban fails the history and tradition test, then what's the argument for treating a suppressor like it's a nuclear device? Or demanding a $200 tax and fingerprints to put a shorter barrel on your home defense rifle? Those rules have no historical foundation. Hell, in the founding era, folks built their own rifles, modified barrels, and passed down suppressors like they were just another tool. And nobody taxed you for it. What Duncan could do is prove that even long-standing federal laws aren't safe if they were built on shaky constitutional ground. We're already seeing lawsuits like Mock versus Garland and Miller versus Garland take direct aim at the ATF's enforcement power. If Duncan lands right, those cases get a tailwind straight from the highest court in the land. And that's where things start to change. Fast, and for good.